Have you received an N13 notice? This video will help you, as a tenant, understand the N13 notice. The N13 notice is a notice to end your tenancy because your landlord wants to demolish your rental unit, repair it, or convert it for another use. When your landlord gives you this written notice, it is a legal notice that could lead to you being evicted from your rental unit. That is why it is important to know your rights and responsibilities as a tenant. It is important to note that an eviction notice is considered legal only when filled out completely and correctly on a landlord and tenant board form, in this case, the N13 form. In the N13 form, your landlord will state three main things. First, they will state that they want to end your tenancy. Then, they will state that they want you to move out by a certain date, which is called the termination date. Lastly, they will state the reason they have for ending the tenancy. With that, they must also state whether they have obtained any necessary building permits. When your landlord states the reason for ending the tenancy on the N13 form, they will indicate one of three reasons for why you may have received this notice. Reason number 1. Your landlord intends to demolish the rental unit or the residential complex. Reason number 2. Your landlord requires the rental unit to be vacant in order to do repairs or renovations so extensive that they are required to get a building permit, and the rental unit must be vacant to do the work. If this is the reason, your landlord must include details of the work they plan to do. But you do have some options in this case. You have the right to move back into the rental unit once the repairs or renovations are completed. Your landlord cannot increase the rent unless it has complied with the legal requirements regarding rent increases. If you want to move back in once the work is done, you must give written notice telling the landlord. You must also keep the landlord informed in writing anytime your address changes. Reason number 3. Your landlord intends to convert your rental unit or the residential complex to a non-residential use. These are the three reasons for why you may have received an N13 notice. As mentioned earlier, the N13 form you receive will indicate a termination date. There are a few things you should know about the termination date. First, the termination date your landlord sets out in this notice must be at least 120 days after they give you this notice. Second, as the N13 is a notice for the end of term, which means that the tenancy is for a fixed term, the termination date cannot be earlier than the last day of the fixed term. For example, if you signed a 1-year lease and the last day of the 1-year period set out in the lease is November 15th, 2024, then the termination date cannot be earlier than November 15th, 2024. Third, the termination date must be the last day of the rental period. For example, if rent is due on the first day of the month, the termination date must be the last day of the month. What can you do if you have received an N13 notice? First, do not move out or agree to move out of your unit until you have obtained legal advice. If the reason for the notice is repairs or renovations, you can exercise your right to move back in after the repairs and renovations set out in the notice are completed. Second, you can terminate the tenancy sooner than the date set out in the notice as long as you give your landlord at least 10 days notice that you intend to move out of your rental unit. If this is what you wish, you must give written notice to your landlord using a landlord and tenant board form called the N9, which is a tenant's notice to end the tenancy. Note that if you move out of the rental unit by the termination date, then your tenancy ends on the date you move out. However, if you disagree with what the landlord has put on the N13 notice, you don't have to move out by the termination date. Your landlord will have to apply to the Landlord and Tenant Board to evict you. You will then receive a notice of hearing from the Landlord and Tenant Board. The Landlord and Tenant Board will schedule a hearing where you can explain why you disagree with the notice. Note that your landlord must apply to the Landlord and Tenant Board for a hearing within 30 days of the termination date indicated on the N13. If they do not apply for a hearing within 30 days of the termination date, then the N13 will be void. You can also try to reach an agreement with your landlord before the hearing. For example, your landlord might agree to pay you more compensation or give you more time to find a new place. If you and your landlord don't make an agreement, your case will go to an eviction hearing at the Landlord and Tenant Board. In most cases, you do have the right to compensation. The amount of compensation depends on the reason on the notice. The compensation must be paid to you on or before the termination date. If you are not offered monetary compensation, you should be offered another unit that is acceptable to you. For more information about your housing rights, visit www.WRCLS.ca. You can also contact Waterloo Region Community Legal Services at www.WRCLS.ca/web-contact or call us at 519-743-0254. You can also check out our YouTube channel for more videos.